Well, thank you very much. So I'm really, as you said, I'm really awfully sorry I cannot be with you today. I really planned and looked forward to participate in the conference and indeed also to discover Cyprus and Nicosia, but it was complete chaos yesterday at Munich airport with an entire huge European airport queuing to know what to do after none of the planes could leave the airport. So actually, I'm glad I could make it back home yesterday night. This conference is a tribute and is in memory to the late Professor Konstantinos Keramios. I would like to say a few words about this and start my speech on this point. So the legacy of Professor Keramios is very diverse. Of course, he was a teacher in Thessaloniki and then in Athens, I could not attend his classes, so I could not comment on this aspect of his career. But there is a very interesting podcast of Simeonides, who discusses the fact that he was his student and he actually loved his classes of civil procedure. So I trust he was indeed a great teacher. Also, I could not comment on his scholarship with respect to Greek civil procedure because I do not read Greek, and therefore I will focus on his contribution at European level. And his contribution at European level is really great. His scholarship again is very broad in this respect. Of course, everybody will know the Evrygenis Keramios report on the accession of Greece to the Brussels Convention. So that's jurisdiction in particular. But since I only have a short period of time, you will forgive me if I choose to focus on a topic with which I relate particularly, and which is international enforcement. And indeed, my perception, and of course that's subjective, my perception of the work of Professor Keramios is that his scholarship was really groundbreaking in the field of international enforcement. He participated in one of the leading commentary on the Brussels I regulation for many years, the commentary of Professor Magnus and Professor Mankowski, who also passed away recently. And he was specifically commenting on the provisions on enforcement. And 10 years ago, he decided that he would stop participating in this project. And I was honored to be asked to continue his work and to comment on the provisions on which he was commenting. So for me, there is a personal relationship to Mr. Keramios, and that's because I was asked to continue his work. But the most important aspect is, I think, his Hague lectures. He gave his Hague lectures in 1997, and so far, it has been the first Hague lectures given at the International Academy the Hague Academy on International Law, which focused only on enforcement. So the title of his class and his course was Enforcement in an International Context. And I think that, and that's why I want to focus on this, I think that he's the first scholar in Europe to have considered that international enforcement could be an important topic for the rest of Europe, and that there was more to say than just there is exclusive jurisdiction of the courts of the forum, and you will always apply the law of the forum. There was much more to say, and indeed, he wrote a very long course on this. And so my speech will focus on the following topic: what is the future of European enforcement law? Is there a future for, in particular, more development in the field of enforcement at the level of the European Union? Let's start with the current situation. So where do we stand in the current situation? Well, the current situation is that European civil procedure, of course, has for a very long time focused very heavily on the enforcement of foreign judgments. As you will all know, this was the primary goal of the most important act of European civil procedure, the 1968 Brussels Convention, which then later became the Brussels Regulation. And that was because there was an article in the Rome Treaty which provided that the member states should get together and conclude a convention which would focus on the enforcement of foreign judgments. And that's only for that purpose that we had rules on jurisdiction in the Brussels Convention. It's because it would serve the goal of facilitating the circulation of foreign judgments. So we know that very well, and for decades that was it. And in particular, enforcement per se, strictly speaking, as the European Court of Justice called it, was left out of the realm of international, of European law. So attachment of assets, freezing of assets, all this was not really in the realm of European law. This was left to national law. So there is an article in the Brussels 1 bis regulation, Article 41, which expressly says so. And the European Court of Justice has repeatedly said that a distinction must be made between enforcement of judgments covered by European law and enforcement per se, so the actual enforcement measures which should not be governed by the law of the European Union. So that was in 1968, and that has been the case since 1968. But in the last decade, a few evolutions have appeared which have shown an interest of the EU to delve into the field of international enforcement. And there are three signs of this evolution, I think. The first is that it was recognized that because enforcement was governed by different national laws, the law of each member state where enforcement would be sought. So because there was a kind of dépeçage, as you say in private international law, you apply different laws to different parts of the same question, enforcement in different parts of Europe. Because of this, this could raise issues of coordination. And therefore, these issues maybe should be specifically addressed by the European lawmaker. And we have a number of provisions on this in European regulations. The clearest is probably the specific provision on the enforcement of unknown measures in the forum. So that's when a foreign court orders a measure of a type which is unknown in other courts and in other member states. And so Article 54 of the Brussels 1 bis regulation now provides since 2012 that these unknown remedies should be to the best possible, as much as possible, enforced with a remedy which is as close as possible in the member state of enforcement. And then another provision which is older is a provision that you find in the Brussels 2 regulation, and which is about arrangement for the exercise of the right of access to children. So here the idea is that it's one thing that the court of origin will say that's how parents should access their children, but you need to care about the enforcement, the actual specific enforcement of this measure. And so for that purpose, it is necessary to ensure coordination between the state of origin and the state of enforcement. And again, there is the same article, actually, Article 54 in the Brussels 2-tier regulation now, which continues to care about this issue. So issues of coordination, which have been dealt with by the European lawmaker, but still not delving into actual law and enforcement. The second major evolution this time is that recently the European lawmaker recognized that there were some issues where cross-border enforcement might require some EU intervention. This here I'm referring, of course, to the adoption of a specific regulation, the EPO regulation that Nicholas will know very well, the EPO regulation, which was adopted by creating a uniform EU conservative measure, protective measure, and which would be available to all the states in Europe. So here I think the goal and the recognition was that cross-border enforcement, freezing bank accounts in other jurisdictions of Europe was actually not possible under the Brussels 1 bis regulation, because in particular, the European case law had laid down a number of obstacles which didn't make it possible. And therefore, the European lawmaker decided that it would delve into the topic and offer a European remedy for allowing this kind of pre-enforcement measures, the freezing of assets in the EU. And finally, there is a third development, which is really minor, so I'm going to mention it very briefly. Because of the abolition of exequatur, there's now a need to care about directly how foreign judgments are received by enforcement authorities, and so there is a switch from the exequatur court to enforcement authorities, and so that is appearing clearly in the Brussels two-tier regulation, where now there's specific provision on enforcement authorities. It's a minor development at the moment, but maybe it will eventually become much bigger. I'm not getting into the details at the present time. Now, we know the present situation, and the question is, should we do more? What about the future? And in particular, should we go further? Should we start harmonizing a bigger part of the law of enforcement in Europe? Should we, for instance, start by adopting common standards on the law and enforcement? Should we maybe even create European enforcement measures? And there are indeed signs that some people are considering just that at the present in the EU. First, in the field of family law, the European Commission has long believed that if there were some common minimum enforcement standards, the chances of effective and expeditious enforcement would be improved in the EU. So here, in family matters, we're talking about enforcement of orders relating to children. That's a specific aspect. But here the European Commission proposed in 2014 to adopt common minimum enforcement standards in the Brussels two-tier regulation so that enforcement of orders over children would be improved. This was not adopted by the European lawmaker, but this is in the mind of the European Commission. Also, some scholars believe in civil and commercial matters, this time in commercial matters in particular, that there should be a further harmonization of enforcement law. And that's the case in particular by two Spanish colleagues, Marta Requiero and Fernando Gascon. They've both written that the fact that national laws of enforcement are unknown in the various member states, unknown meaning not by local lawyers, you hope, but by the lawyers of other countries. The fact that when you want to enforce your judgment in another country, you do not know the content of the law of enforcement in that other country. They believe that this is creating a problem because this might deter the enforcement of foreign judgment in other countries. So in other words, because a creditor would not know how the law of enforcement functions in another member state, this creditor would refrain from enforcing his judgment in another member state. And so they argue that knowledge of the law of other member states in the field of enforcement should be improved, and maybe common standards should be adopted to improve enforcement of foreign judgments. Finally, and although it's not in the EU, I want to mention a recent initiative of UNiDROIT. So UNiDROIT, which is this international organization based in Rome. And so UNiDROIT has started a few years ago a project focused on enforcement. And this project aims at setting global standards of enforcement for offering a model to domestic lawmakers. So here it's a bit different. Here the idea is that many countries in the world are reforming their law of enforcement, and that maybe UNiDROIT should offer a global or a best instrument, a best practices instrument, so that lawmakers in the various countries would seek inspiration and possibly adopt legislation modeled on what UNiDROIT would have produced. So here the idea is that to improve the laws of the various states in the world, experts should gather and identify global standards for international enforcement. And so maybe this could be, and that's the argument, maybe this could be adopted also at European level. Well, what should we think about these three proposals. First, the issue of coordination. I think that that is what the EU has done in the Brussels 1 bis regulation and the Brussels 2-ter regulation. It is one thing to say that the law of enforcement governs separately in the different states, but it is another thing not to care about coordinating these different laws. And so I think that each time there is an issue of coordination, the EU should step in and improve the coordination by specific measures. So here, this doesn't mean changing the laws of enforcement of each of the member states. It only means improving enforcement between the laws of two member states, the law maybe of origin of the creditor, and the law where enforcement is sought. And so I'm all in favor of this. One important aspect of this is, for instance, the law of interest. When interest is stipulated, how do you enforce an award with interest in another member state? Clearly here, there is a need for coordination, and the EU lawmaker should step in. But as we've seen, there are calls which are much broader than this. And so I would like to discuss in particular the call of my two Spanish colleagues who say that we should go farther. We should actually improve knowledge of foreign enforcement law and possibly adopt common standards so that creditors would not refrain from enforcing their awards in other member states. I think that this is a wrong idea. This is a bad idea. And the reason why is as follows. When a creditor wants to enforce a judgment, and this creditor is a business, can you really think that he cares about the law of enforcement in another member state? He doesn't know the law of enforcement. Actually, he doesn't know the law of enforcement in his own member state, which is why he will turn to a lawyer. Nobody except lawyers know very well the law of enforcement. And actually, it might be even a specialized field of the law in each member state. So the issue is not for the client, it's not for the creditor to know the content of the law of enforcement in his own member state and in foreign member states. It is for his lawyers. So when we talk about who might be deterred from enforcing in another member state a judgment obtained in a first member state, when we talk about this, who are we referring to? We're referring to lawyers. In fact, the question is whether the client, the creditor, when he wants to enforce this judgment, whether he should still remain with his lawyer of origin. If he obtained a Greek judgment and he wants to enforce this Greek judgment in France, should the enforcement in France be dealt with by a Greek lawyer, because this is a Greek judgment? Is that the idea? And so, of course, if you think that the Greek lawyer should care about the enforcement of the Greek judgment in France, then you would want this Greek lawyer to know about the law of France. And because that's very complicated to maintain anything updated, maybe you would want to have EU standards so that the Greek lawyer can enforce in France this judgment. But the truth of the matter is that it's not really useful. Why isn't it useful? It's because there is no reason to retain a Greek lawyer to enforce your judgment in France. What you should do is that you should retain a lawyer where you want to enforce your judgment. So it's not, the lawyer in Greece was very useful to obtain the judgment. That was his job. That's where his intervention was useful and contributed to the welfare of his client. But there is no reason why this lawyer should continue to deal with his client when he will be enforcing the judgment abroad. So you will turn, and the client should turn, to a lawyer in another member state, and this lawyer will know perfectly well the law of enforcement of his own member state. So I do not believe that there is any need to improve knowledge of foreign lawyers of local law of enforcement for the reason that I've just described. It economically makes no sense, and I think it economically makes no sense. Finally, and I will end on this point, finally, the last question is whether the UNic project is meaningful for the EU. And here I recall that the UNic wants to improve the laws of enforcement of each of the member states. And I think that here it's not really meaningful for the EU. It's not really meaningful for the EU because it's not the job of the EU to care about improving the local enforcement laws of the member states. So that's an issue. The subsidiarity here should play a role. It's for each member state to discuss and decide about its own law of enforcement and the efficiency or the efficacy of its law of enforcement. And so the principle of subsidiarity militates against the EU stepping in, just improving national laws as opposed to improving cross-border enforcement of judgment. So to conclude, Professor Karameris was a groundbreaking force in the field of international enforcement law. He did so when everybody believed that when there was a dogma, actually, that international enforcement law should be entirely territorial. I'm sure that before he passed away, he witnessed with great interest these evolutions, and I hope he would agree with me that we need not go that far, as some of my colleagues have proposed. So thank you very much for your attention. And again, I'm really highly disappointed I couldn't make it to Cyprus, and I hope that there will be other occasions. Thank you very much.